Hello, I am Parvati Nambiar and this is LiveLaw. Recent events in Maharashtra have been catching all the national limelight and much debate is going on about the anti-defection law. In this video, I will attempt to explain the political crisis in Maharashtra and what the anti-defection law under Schedule 10 of our constitution has in store for the Shiv Sena and its rebels. To give context, I will first explain the political scenario in Maharashtra. The Maharashtra State Legislative Assembly has 288 seats, meaning that for a party to be considered a majority, they must win at least 145 seats. Now, in the 2019 elections, the BJP, led by Devendra Fadnavis, won 106 seats. The Shiv Sena, led by Uddhav Thackeray, won 56 seats. The NCP, led by Sharad Pawar, won 54 seats, and the Indian National Congress got 44 seats. The Shiv Sena and the BJP could not form a coalition because they refused to share the Chief Minister's position equally for 2.5 years. Since there was no explicit majority, the President's rule was imposed for a short period before Devendra Fadnavis stepped in with support from a small fraction of the NCP led by Ajit Pawar, the nephew of Sharad Pawar. However, they could not prove majority. And soon, the Shiv Sena stepped in, forming an alliance with the Indian National Congress and the NCP. The alliance of these three parties came to be known as the Maha Vikas Aghadi. And this is the ruling alliance in Maharashtra right now with Uddhav Thackeray as their Chief Minister. Now coming to the 2022 political crisis. There were clashes erupting between the members of the Shiv Sena party, and these clashes became evident following the Maharashtra Legislative Council elections in June 2022. In the election, Shiv Sena was expected to win 6 out of the 10 seats. However, Shiv Sena only won 5 and the rest 5 were won by BJP, meaning that some Shiv Sena leaders had cross-voted for BJP. After this clash became evident, Eknath Shinde, a senior Shiv Sena leader and former party whip, moved to Surat, Gujarat along with a couple of other MLAs. The number of rebel MLAs grew day by day and they then accepted Eknath Shinde as their leader. Now comes in the anti-defection law. Defection is basically when the politically elected representative of one party after being elected either voluntarily gives up his party membership or fails to participate in a crucial vote. Now, under Schedule 10 of our Constitution, such legislators can be disqualified for the remainder of their term. However, there are exceptions to being disqualified. There is a general assumption now that if Shinde garners the support of at least 2/3 of the Shiv Sena MLAs, that is 37 Shiv Sena MLAs, they can be exempted from such disqualification. However, such an assumption has no basis in law because the 10th schedule no longer recognizes the split within a political party as a valid exception. A detailed article has been written about this by Manu Sebastian on our website, the link for which will be given in the description of this video. So coming back to our discussion, the 10th schedule in paragraph 3 did earlier recognize the split within a political party wherein 1/3 of its members had left that party as a valid exception. However, this paragraph 3 was omitted by the 91st Constitutional Amendment in 2003. What now remains is paragraph 4 as an exemption. Now, under paragraph 4, the valid exception to the disqualification will happen in the event of merger with another political party. To put it simply, the first condition to be availing such an exception is that the original party, in our present case, the Shiv Sena, would have to merge with another political party. And this merger would have to be supported by at least 2/3 of the MLAs, that is 37 MLAs. In this case, the remaining 1/3 MLAs also would not be disqualified. Therefore, unless the rebel MLAs in the current instance associate a merger with another political party, they will not be protected by the exceptions given under Schedule 10. Now, another important question that arises at this juncture is whether the actions by the MLA amount to defection. Now, under paragraph 2 of Schedule 10, defection is seen as when a party representative either voluntarily gives up his party membership or fails to participate in a crucial vote. The Supreme Court has given a very wide ambit as to what can be seen as a voluntary giving up of party membership in Ravi S. Naik versus the Union of India in 1994. The Supreme Court stated that in the absence of a formal resignation, the inference can be drawn from the conduct of the party member to see if he has voluntarily given up his party membership. Now, in our present case, the rebel MLAs followed Eknath Shinde to Gujarat first and then to Guwahati, Assam. They wrote a letter to their deputy speaker, Narhari Zirwal, stating that they identify Eknath Shinde as their group leader. Therefore, the real issue to resolve here is whether such actions by the rebel MLAs will be seen as a valid defection. In conclusion, unless the rebel MLAs associate a merger with another political party, they will not be absolutely shielded from Schedule 10 of our Constitution. The authority to decide whether or not an MLA can be disqualified on grounds of defection lies with the Assembly Speaker. However, currently the post for the Assembly Speaker remains vacant in the Maharashtra Legislative Assembly. Which brings us to Article 180 Clause 1 of the Constitution, which states that in the event the post for the Speaker is vacant, his duties would pass on to the Deputy Speaker, which gives Narhari Zirwal, the current Deputy Speaker, the duty to decide if the rebel MLAs can be disqualified on grounds of defection. On June 25th, Zirwal served disqualification notices to 16 of the rebel MLAs, including Eknath Shinde. Shinde, on the very next day, filed a writ petition at the Supreme Court, challenging these disqualification notices. In the writ petition, it is stated that the disqualification notice has been passed while there is a no confidence motion pending against Narhari Zirwal, and that during the pendency of such a resolution, he cannot pass such disqualification notices. It further states that Zirwal is an active member of the NCP and therefore is politically motivated in giving out such disqualification notices. Senior Advocate Rajiv Dhawan, appearing for Zirwal, stated that no decision will be taken on the disqualification notice in the meantime. Senior Advocate A.M. Singhvi, appearing for Shiv Sena leader Ajay Chowdhury, stated that the court cannot interfere in such a matter while it is pending before the Speaker. The matter will be next heard on the 11th of July. In the meantime, public interest litigations have been filed at the Bombay High Court, stating that by camping away in Assam, the rebel MLAs are neglecting their duties and has asked the court to issue directions to bring them back to Maharashtra. Yet another public interest litigation states that the rebel MLAs are camping away in Guwahati because they face a threat to their life, and has sought to file FIRs against the Chief Minister and his son for public nuisance and sedition. Stay tuned to LiveLaw for more updates.